Shelley, can you hear us? Okay, thank you. All right, at this time, we'll have any bill introductions. Are there bill introductions? Sean.
Thank you, Madam Chair, members of the committee. My name is Sean Miller. I'm here to request a committee bill introduction on behalf of my client, SCI. It is 21 RS 0549, and it is an act concerning cemetery corporations.
Okay, would you give those last four digits again?
Yes, ma'am, 0549.
Thank you. All right. I have a motion to approve. Senator Warren?
I'm sorry, I didn't mean to signify I needed.
Well, you were just telling me you have your.
We have the paper.
All right, I'm going to let these guys go for it. Senator Francisco, did you want to make a motion? Seconded by Senator Bowers. Discussion. Seeing none, all in favor say aye. Opposed, no. Motion carries. Thank you, Sean. Are there any other bill introductions? I don't see any. Senators, you received the minutes of January 12th, January 14th, and January 21st. I'd like to have those approved. I have a motion by Senator Bowers, second by Senator Francisco. Discussion. Seeing none, all in favor say aye. Opposed, no. Motion carries. Thank you. We will, I think we'll go ahead and take up Senate Bill 53. I think it's non-controversial, so, and we had the hearing on it. Was there anyone else that wanted to speak on this issue that are via WebEx? Seeing none, is there any other possible amendments to the bill, Senate Bill 53? What's the will of the committee? Senator Bowers.
Thank you, Madam Chair. I move we pass out Senate Bill 53 favorable and place on the consent calendar.
I have a motion. Second by Senator Falscadeau. Discussion. Seeing none, all in favor say aye. Opposed, no. Motion carries. Now we're back on Senate Bill 52, creating the Sedgwick County Urban Area Nuisance Abatement Act. Do we have, this was one we did not finish, and I had to cut down some questions, but Senator Haley's not here right now. Is there anyone on WebEx that wants to speak to this bill? Seeing none, is there anyone in the committee room that has any amendments or comments? Senator Dahl. Okay. Do you have copies for the committee? Okay, just hand it. We'll just pass it around. That way you don't have to walk around. Oh, problem. Senator Dahl, would you like to explain your amendment? I've not heard any objections. Are there questions on the amendment? Senator Falscadeau.
Thank you, Madam Chair. Senator, so do you know why it just said motor vehicles used for ag purposes? Why not just motor vehicles? Or
Many times, farm machinery is generally oversized and very different from a regular vehicle. Any other questions? Senator Straub?
Thank you, Madam Chair. I do kind of wonder about this a little bit, just from being a former county commissioner. I'm not new to dealing with nuisance-type things outside of city boundaries and on county private property. I wonder if most of these issues, if there's a true public health or public safety risk, are these things not already covered under current statutes with KDHE?
Are you referring to the amendment? We're on this specific
Just
amendment.
the amendment?
We'll get back on the bill.
Okay, thank you. I'll wait.
Senator Warren, did you have a question?
Yes, Madam Chair. Kind of following the other senator's question, would it be helpful to tie the definition of agricultural purposes to other areas of Kansas statute that defines what agricultural purposes is? And maybe that's a question for the reviser. Do we have definition in statute already for agricultural purposes that would help define this in addition to this amendment?
Before we refer to the reviser, Randy, did you have any comment on that, or I'm sure you were behind helping draft the amendment?
Oh, I'm sorry. Randy Stuckey, Kansas Grain and Feed Association, Kansas Agribusiness Retailers. I did draft the additional language for grain elevators and ag retailers to the existing language that excludes property for agricultural purposes. We drafted the additional language broadly to include, so there wouldn't be any misunderstanding, that we do intend to exclude all grain elevators, property, crops, stored crops, and ag retail inputs, and all personal property that would be pertinent there too. So if we went to borrow language that's close, currently defined in statute, maybe a little difficult to find that one place that does capture all those equipment that we intended to capture through this intentionally broad language today. We would prefer the broader language that's in the proposed amendment. Yes.
Is there a reviser that'd like to comment on this?
Madam Chair, I was not made aware of this amendment prior to the meeting. I have not seen it, and I could not hear Senator Dahl when he offered the amendment, so I have no comment on the contents of this amendment at this time.
Okay, thank you, Jason. Sorry about that. We need to communicate better to you, for sure. I think Senator Francisco is next, and then Senator Warren, you have a question?
Thank you, Madam Chair. I generally support this amendment, but as pointed out, motor vehicles would be the most difficult. Motor vehicles would be the most difficult item to decide whether or not it's used for agricultural purposes. And so generally, if you have a car, it probably should be running if you're going to use it for agricultural purposes. So I think just striking that from this would limit it, also include the majority, and I think really all of what the intent of the amendment would be.
Senator Warren?
Thank you, Madam Chair. The amendment, I think, as written, is helpful to help define what we mean in the bill by agricultural purposes, and I think the amendment would be helped to also tie the definition of agricultural purposes, which I believe has a specific definition in statute. If we could tie, and that was kind of my question for Mr. Reviser, do we have something already in statute that we could insert in the bill after the words agricultural purposes and before the amendment language? I think it would help answer some of these questions. What do we mean by motor vehicles used for agricultural purposes? Well, we already have a definition in statute, and here it is, and let's insert that in the bill would be my suggestion.
Senator Dahl?
Thank you, Madam Chair. Just a side note on Senator Francisco's comment, and on the farm, like our fencing pickup would, it might not fall, you know, it was used to build fence. If you did it for anything else, it would probably violate most anything, any category. So it would fall under this agricultural purposes, but I think it would probably be, it wouldn't fit real well with what we're trying to accomplish with this. And so I understand, you know, with the vehicle purposes, some of the things that we use, they have trucks that are used to hold seed in. And so for agricultural purposes, I think that the vehicle aspect needs to stay there, personally.
Senator Erickson?
Thank you, Madam Chair. Just a quick question. I don't have any issue with the amendment and making sure that we define agricultural issues as well. But my question is, in the amendment, it specifically mentions applying to land. And I'm looking at the bill, and I'm not seeing that specific designation in the bill. And I would think there would need to be consistency protecting the land of people in the bill as well as in the agricultural aspect. Thank you, Madam Chair.
Thank you. Senator Fasquedo?
Thank you, Madam Chair. So I'll probably support the amendment, probably even the bill. But to Senator Marcy Francisco's point that if it's a motor vehicle that it should be operating, you know, we really have to be realistic and take into consideration of COVID-19, and people have lost their jobs. And so I know a lot of poor people that, you know, a flat tire, you know, they need a new transmission, and so therefore that vehicle may not be operating. And understanding the purpose and the goal of this legislation being that this would be outside of the city limits listed in the original base bill that we're dealing with. I just, you know, I'm always trying to be fair and just. And so I guess who brought the amendment forward, and I'm not looking at the actual base bill, Madam Chair, to know if we even mentioned in the original bill of you know, we're talking about abandoned property. I don't know. I just, cars are hard to come by, and I just wanted to also protect those who, a motor vehicle that may not be used for ag purposes. So I don't know if anyone can address that, but that was my concern. I don't want you to take people's vehicles just because they can't afford to repair them if they're not a nuisance. Thank you, Madam Chair.
I think we have statute that deals with how many cars can sit on a property, and then if your car breaks down on the roadside, you know, you get the little red sticker and you got so many days to take care of it. So I think we have laws that address that. Senator Haley?
Along the same vein, thank you, Madam Chair. And I guess probably this is for the maker or the mover of the amendment, which I tend to support the amendment. I guess my concern, I asked it during the committee, was what about that old barn? It was represented that part of the reason for this underlying bill are for structures that are deemed unsafe and that may be attractive nuisances or that might lend themselves to, you know, danger, some harm, a dangerous building. So we've all seen them driving down the highway, that big old barn that's 2 seconds away from collapse. This amendment, at least in my mind, will protect that old barn that's 2 seconds away from collapse. and even though it's a dangerous building and a nuisance. And if that's what the maker of the amendment intends. Now, full disclosure, I like this because I'm concerned about the underlying bill. So, but it is a carve-out for certain businesses. The chair just referenced how many cars could be on a lot, for example. So an old car lot, even though it's a business in a rural area that's equal to, in many ways, agricultural business, it won't have that protection because it's not agriculturally related. I'm okay with it, but I'm just saying, what about the old barn? How long can it stand as a dangerous building when we adopt your amendment?
I think I'm going to recognize somebody that's on the WebEx that is the Director of Permits Building Inspection, I believe for Sedgwick County. Chris Lambrum, are you on?
Yes, Chair McGinn. Chris Labram here, Director of Metropolitan Area and Building Construction. Thank you, Senator. Do greatly appreciate you all hearing us this morning, and thanks for your time. We were not able to hear all of what was stated with the amendment, but from what we do hear, we certainly do not intend to target anything agricultural with this. So if there is amendment language to support further defining that, we certainly would support that. To speak to specifically the barn situation, so we have a unique situation with our urban designation where we have improvement districts and we have neighborhoods that are just outside of the city limits. So the buildings that we see there, those dilapidated and very dangerous structures, they are very accessible to the public. Note that our process, we in no way intend to change our processes with this. So our process currently is complaint driven, currently goes through a very robust evaluation process that includes court and a judge's determination on this. So we would not change that. We would certainly not be looking in any way at any level of eminent domain or any situation where the ownership of property would change. So all of that would certainly not be a factor here. And again, I guess to back up a little, my department is in charge of nuisance abatement, housing code in the city of Wichita as well, and then also in the unincorporated Sedgwick County. So I feel we're very well versed in keeping those separate. I put a lot of effort into separating those processes with the abatement powers that cities are given, and ensuring that we have the proper due process there. Note that this bill then, in addition to the nuisance definitions that are currently included in our code, this would require those to be a danger and a menace to the inhabitants of the county. So in order to have a barn that was just described meet that situation would be very unlikely. And then you would also have the addition of the agricultural exemption for that as well. So I do not see that being a factor. Noting also that this would be enabling legislation and the particulars of defining nuisances and the process to go with those would be further defined by our commission when we develop the county code associated with it. Does that answer your question and more, Senator?
I think that was very helpful, yes, and he's nodding his head. Senator Dahl, did you have another comment or? Okay. All right, we're back on the amendment. Senator Warren.
Thank you, Madam Chair. I don't know if we could ask the reviser if there's a Kansas statute that defines agricultural purposes, and maybe, I guess if there is, which I believe there is, we could then amend the amendment a little further with the carrier's permission to insert that.
Jason, have you had a chance to take a look at the definition of agricultural purposes?
Yes, Madam Chair. There is a definition of agricultural purpose in the Consumer Protection Act that essentially defines purposes related to the production, harvest, exhibition, marketing, transportation, processing, or manufacture of agricultural products by a consumer who cultivates plants, propagates and nurtures the agricultural products. So it's a definition in the context of the Consumer Protection Act and not necessarily in terms of agricultural regulation. So there is that one. And then it goes on to define agricultural products pretty extensively for just about any kind of plant or animal product that you would grow or raise on your land. It's a pretty extensive definition.
Senator Warren.
Do we have any concerns that that's a definition from, I guess, a different subject matter in the law? That would be a question, I suppose, for the reviser, Madam Chair, that, and I would just want to know his thoughts on that, if possible. Causes me a little concern.
Madam Chair, I would want to read the definition and its use in that act a little bit more closely before applying that definition in another context such as this, when we're talking about an exception for a public nuisance, just because it isn't from an agricultural context, but from a consumer protection context.
Senator Warren.
Thank you, Madam Chair. I hear the concern and I share the concern. I believe we have a definition of agricultural in the Right to Farm Act. I think it's KSA 2-3203. That might be more applicable. And Madam Chair, if it would be something we want to continue the discussion for another day, or, I mean, I think this is important. We want to get this right.
I agree. I think maybe there needs to be some adjustments on this amendment. I'm going to take two more questions, and then we're going to move to other amendments. And I have Senator Francisco next.
Thank you, Madam Chair. As we look at this amendment, because we're talking about a nuisance at a particular place, it may also be possible to identify those places or identify it as agricultural land rather than agricultural purpose. And I will talk to the reviser more about that.
Okay, thank you. Senator Fascadeau? No questions. Any other questions? Okay, we're going to pass over this amendment and move on to any other amendments. Senator Warren?
Thank you, Madam Chair. I have three amendments. They're basically in the nature of kind of cleaning up the procedure that we're looking at for the nuisance here, and I believe that they kind of balance the governmental interest and the private property owner interest. So I'll pass the first one out now with permission, if that's all right.
Just for the committee, there might be hope. I hear that they're waiting for the company to put this system in. There's like a couple rooms that ring, and so maybe in a week or two we'll have this fixed.
Madam Chair, we're just passing out the First Amendment now, so if you'll just take the one copy and
All right, Senator Warren, would you like to explain the amendment?
Thank you, sure. The First Amendment is on page 2, lines 1 through 5, and it's an issue that I talked about when we were hearing the bill on Tuesday. It provides a definition for personal service. I think that private persons need to know how to expect to be served, and our government needs to abide by due process and make sure that if we're going to do something that affects your private property, you ought to be served with proper notice. So what the amendment does, it ties the definition of and provides a definition of personal service to Kansas statute that already exists, and it's there in the amendment, KSA 60-303, and that defines how you would provide personal service in the instance of a lawsuit. So there are certain mechanisms to ensure that the private property owner is going to be notified properly, so they're not surprised. The county's going to go through every effort, every step to make sure that the private property owner is duly notified. And then the amendment also strikes the last line of Section B, and it strikes that the last sentence, I'm sorry, because those circumstances are already defined in statute in Kansas by KSA 60-303. So it kind of clears up what kind of notice the county's required to give and what kind of notice and protections the private property owner has. And I'll stand for questions, Madam Chair.
Questions on the amendment? Senator Haley.
The amendment being offered, just point of procedure right now, is she offering that, or are you going to undertake this now? I guess the question I have, Madam Chair, Senator Warren, there are ever-expanding means of personal service that will include electronic. I just had this discussion. We're having a tax sale this morning in Wyandotte County. And a lot of my friends, clients, neighbors have called because they were not served notice. And our county in Wyandotte are taking their property through this tax sale as we sit here electronically because they were not notified, or so they say, that there was not proper notice. Oddly, this is akin to me, akin to the circumstances to me. So I certainly support the amendment wanting to ratchet down direct contact with the disaffected property owner. And it's just ironic that it's being held now. But I just want to know, in the ever-expanding definition of adequacy of the statute, would this contemplate your amendment, the changes that we have to other means of service, such as electronic, as being acceptable or due notice, I guess, to the property owner?
Senator Warren.
Thank you, Madam Chair, and appreciate the questions. And the amendment is meant to alleviate and assist the private property owners so that they do get adequate and proper notice. To answer the question specifically, KSA 60-303 does not currently, I believe, allow for electronic notice. But if the legislature were so to determine that that's something we want to do, the amendment provides for those sort of future changing circumstances, because you'll see that the amendment also includes and amendments there too, to how we get personal service on private citizens. So it would be taken into account if that's something the legislature wants to do, to allow service by electronic mail. This would move along with what the legislature intends in other areas as well.
Thank you, Senator Warren. I agree that that's something in the future for electronic service. But right now, there has to be adequate notice for all types, especially where it's concerning the deprivation of a real property right, potentially. Thank you. Thank you, Madam Chair.
Thank you, Madam Chair. And I did want to follow up that I did discuss with Mr. James Howell, the Sedgwick County Commissioner, who testified in support of the bill, and he considers this a friendly amendment and helpful to help clarify what we're doing here when we're abating a nuisance as a county in an urban area.
Thank you. Senator Bowers.
Thank you, Madam Chair, and that might have helped Senator Warren, too. I was looking at his testimony on page 2, Commissioner Howell. The amendment, does it narrow down, make their process easier? Because they had 11 steps on here, I think, that were pretty defined to me as how they're going to do this. I felt very comfortable with that. Does your amendment even tighten that up more? If it's going along with how lawsuits are delivered, I'm going to say yes, that it's would be similar process and yet at a high standard too. So but just looking at his 11, but I'm not certain how, not seeing what KSA is. You might know a little more about that, the 60-303. And I'm fairly confident that it's at least similar or better yet, good procedure. But thank you for taking a stab at that.
Senator Warren, did you have a comment?
If there was a question, thank you, Madam Chair, I can answer it, but if there's a question.
Thank you, Madam Chair. Is it similar in their process that they have through 1 through 11 already that they proposed?
Thank you, Madam Chair. I'm looking at steps 1 through 11 proposed by the county. It's a subsection of that process, I would say. This helps get the process rolling and helps ensure that as the private property owner goes through these 11 steps with the county, that they're notified, hey, this process is starting. And if I want to be involved in these 11 steps, I need to respond to the personal service, the notice I just received. So I would say it enhances those 11 steps, just to get the ball, if you will.
Any more questions on the amendment? Seeing none, I'd entertain a motion to approve this amendment. Have Senator Warren.
Thank you, Madam Chair. I was just going to move my amendment.
I have a motion, second by Senator Thompson. Discussion. Seeing none, all in favor, say aye. Opposed, no. Motion carries. We're back on the bill. Senator Warren.
Thank you, Madam Chair. I have a second amendment that I will pass out now, and it also helps clarify some of the definitions in the statute, and also was discussed with Mr. Howell, and he considers it a friendly, helpful amendment to help clarify what the bill does. If I may explain. Also on page 2 of the bill, and it helps define owner. I discussed on Tuesday, there was discussion that sometimes there's more than one owner, and the bill as written only contemplates one owner. It also talked about agent of the owner. An agent has a very defined legal definition that wasn't necessarily defined in the bill. Sometimes there's a registered agent. Sometimes an agent can be any person acting on your behalf, and so I thought it would be helpful, again, to all interests here, to help balance the interest, that if we're talking about motor vehicles, we're talking about real property. These are all items that have owners of record. So if we can get personal service on the owner of record, then we have, again, ensured that those who are having their property subject to government action are duly notified. And in the case of more than one owner of record, the amendment provides that notice needed to be given to at least one of the owners of record, and then the county could proceed with the 11 steps if that's what they've outlined to do. So with that, I'll stand for questions.
Questions on the amendment? Senator Fascadell.
Madam Chair, not a question, just I just want to give kudos to Senator Warren. You're awesome.
Senator Francisco.
Thank you, Madam Chair. I see we're striking the words agent of the owner. In some areas, especially if there's rental property, the municipality may ask for a list of agents that can be used for contact. Why are we eliminating that?
Senator Warren.
Thank you, Madam Chair. That is one area where, you've got the management company who manages types of property like that. Since we're looking at an unincorporated area, it's where the bill would apply. It's probably not going to be an area where you've got large apartment complexes that are being managed by a management company. The amendment provides even more, I would say, notice for the owner of record. So it ultimately, it's the owner of record who stands to lose if they don't have these protections. It's not the management company, because the management company doesn't own the property, but it would be the owner of record. So that's why it's written the way it is.
Senator Francisco.
Thank you, Madam Chair. And I would just comment that the ordinances that I'm familiar with do not ask for an address for a management company. They allow the owner to identify an agent. So if an owner of property is out of the state or out of the country, then there is a clear means of contact. I agree that may be more found in ordinances of cities than
Senator Haley.
But thank you, and I like the way you're thinking, Senator Warren. I do know, though, that there are some properties that are truly owned by LLCs, and they have, I'm registered agent for a few LLCs in a rural area. So I am not the owner, but the LLC is. But as a registered agent, I would accept service for, and the LLC. How would your amendment affect small companies or LLCs that own property who are not owned by an individual owner?
Senator Warren.
Thank you, Madam Chair. And with the adoption of the First Amendment that we just had regarding personal service, the beauty of KSA 60-303 includes how do you get personal service on an owner who's not an individual, but is an LLC and has a registered agent. KSA 60-303 provides how you do that. You send it to the registered agent for the LLC by certified mail, those sorts of things. So it would include LLCs who have registered agents. So we're not getting rid of the registered agent necessarily, but it's, in my opinion, more appropriately placed in the personal service aspect of what KSA 60-303 requires. When you have an LLC owner, when you have someone who's an owner that is subject, to the jurisdiction of the military because they're a service member, there are all kinds of provisions to make sure that in those certain categories, those people get proper notice as well.
Thank you, Madam Chair.
Senator Francisco.
Thank you, Madam Chair. My concern then would be, should we restrict the order to personal service so it is all within personal service? Because right now, personal service is just a choice that the county has. They could also serve notice on the owner by certified mail, and in that case, the certified mail should probably go to an agent if there is one.
Senator Warren, would you like to comment?
Thank you, Madam Chair. That's a point well taken. If we make personal service as defined in statute already, it already talks about, KSA 60-303 already talks about, you can personally hand it to them, you can do it by certified mail. So that's something that could probably be cleaned up as well, which would then be an amendment to my second amendment, I suppose, since we've already passed the First Amendment. Let's, if Madam Chair would entertain.
I don't think we're going to kick this bill out today, so if you could make any cleanup adjustments, we can take it up right off the bat, but I want to make sure we have all the discussion taken care of today if we can. Okay, we're back on the amendment. Are there other questions on this amendment? Now, do I understand, Senator Francisco and Senator Warren, that we could pass this amendment and then we'll make adjustments to the First Amendment? Senator Francisco.
No, I think that the same language is in both amendments. So if we, I think we could consider just striking on page 2, lines 1 and 2, shall be served on the owner by personal service. And Senator Warren can help me if that would clean this up.
Senator Warren.
Thank you, Madam Chair. I believe that would clean this up.
So is there agreement to pass or vote on this amendment with adjustments? And we'll look at it again, and you can come back into it when we take this up. Would you like to wait?
Madam Chair, if it's the will of the chair that we strike the additional language and do that today, or you'd like me to come back with a clean amendment tomorrow, whichever.
I would like to make a motion that we will approve this amendment with the adjustments that we have talked about, and we'll have them cleaned up when we come back next week.
I would support that motion.
Okay, would you like to make that motion?
Oh, sure. Madam Chair, I move then on the amendment number 2 that we adjust the language on page 2, lines 1 and 2 by striking also or agent of the property by certified mail, return receipt requested, or that we strike that language. However, now that I see, we need to add then owner of record to there. To the, shall be served on the owner of record by personal service would be the revisions that we're doing today by oral motion.
I think Senator Francisco seconds that. Who's going to whether she raised her hand or not. Okay, so this amendment with adjustments is the vote. So all those in favor, discussion, Senator Haley.
Could somebody then just read language? I mean, I think I'm pretty sure I'm in support, but if I'm reading it, can somebody just read from line 1 to line 3, how it would then read, or whatever, if this is adopted? And by the way, doesn't that have to be repeated further in the bill? I think it's referenced again, the same terminology, I think further down. There are 2 places I think it's referred to in the bill, same language.
Thank you, Madam Chair. So you've got the written copy of amendment number 2 in front of you, and the revisions would be on page 2 at line 1 to strike or agent of the property by certified, and then on line 2, mail, comma, return receipt requested, comma, or. And we do not need, I believe, to insert owner of record, because amendment number 2 at the bottom of page 2, the balloon amendment, includes adding new section G, which says all orders and notices shall be served on the owner of record. So I think that takes care of.
Thank you. And I think we have an agreement by the person that seconded. Is that correct? Senator Francisco, agreement? Okay. All right. Get one more crack at it. Since we're not going to finish the bill, but we want to keep moving on and we want to see that language. So have a motion second. Any other discussion? Seeing none, all in favor say aye. Aye. Opposed, no. Motion carries. Sarah Warren.
Thank you, Madam Chair. One third and last amendment, again, just kind of cleans up the language a little bit and provides some further definition. This was also discussed with Mr. Howell from the Sedgwick County Commission, and he, again, considered it a helpful and friendly amendment. And it is on page 2, again, of the bill at the bottom there. And it adds, I see we can't have 2 new section Gs, but the revisor will work that out. But it would add a new section to give the property owner a right of appeal of the hearing of the Board of County Commissioners. Right now, if you disagree with if you've requested a hearing and you disagree with the board's determination, you have no recourse to follow through with. So this merely provides, as we do in other places in Kansas statute, that the decision of the Board of County Commissioners is subject to review in accordance with the Kansas Judicial Review Act. And most likely that won't be used very often, because the reason that the nuisance act, the abatement of a nuisance act, is being used in the first place is because you've got non-responsive folks, and but it just provides additional protection, as we have in other areas of law, that when your private property is being affected, you have rights to make sure that it's done in accordance with due process. And with that, I'll stand for questions, Madam Chair.
Questions? don't see any. Would you like to make a motion?
Thank you, Madam Chair. With that, I move my motion.
I have a motion and a second by Senator Thompson. Discussion? Seeing none, all in favor say aye. Opposed, no. Motion carries. We're back on the bill. Senator Straub, did you want to make a comment before we leave today in case this was something we needed to discuss next week?
Yes, this is something that I think specifically could encroach on private property rights. I don't want this to set precedent for the rest of the state because this is a specific urban area. And I guess I question if some of these things are already covered in state statute under public health and welfare. If they're not already covered in statute, but they're not being pursued by the state, the county is trying to abate these issues. And there's also one other question in the bill on, let's see here. On section 1D on line 16, it says the abatement of any nuisance. Is nuisance defined anywhere in state law, county statute? That's my question, because I mean, use an example. If my neighbor has a rooster that wakes me up every morning, I may just hate roosters. Can I file a complaint with the county, and can they make my neighbor get rid of their rooster? I just don't want this to go down that slippery slope.
Right. I'm going to recognize Jason Long in a minute, but I know some of the committee you could slip out. Before you do, I want to make sure you can have your favorite reviser or who you're comfortable with drafting amendments, but if you would please ask whoever that individual is to always CC Jason Long, because he is our official reviser for this committee. Jason, do you have a comment on Senator Straub's question?
Thank you, Madam Chair. Senator Straub, I believe the intent of this bill is to provide additional procedures for the county to abate nuisances that are not available to them through existing nuisance abatement statutes. But to your question on a definition of nuisance, it's essentially defined by the local county code. There'll be local county ordinances adopted by the county commissioners that define what constitutes a nuisance. And so if you look in the bill up on lines 10 and 11 and 12, the county has to obtain a conviction for a county code violation before they can proceed to take any action under this act. And so that would be a violation of the county's nuisance ordinances in order to then take action to abate that nuisance.
Senator Straub.
Thank you. So I guess my question is, this nuisance could essentially be just about anything that the county commission adopts as what they consider a nuisance.
Yes, it would be whatever the county ordinances define as being a nuisance through their standard process of proposing, reviewing, and voting on ordinances for the county code.
Generally, it goes through a planning and zoning process before it even gets to the county commissioners.
Right, and are the issues that were presented to us, the photos and things that were provided to us, those examples, this is another question. Are they within that 3-mile zoning? And I don't know if Wichita has, or if Sedgwick County have those 3-mile zonings. Are these nuisances specifically in that zone that they could be handled under different zoning regulations? Or are they further out in further rural areas of the county where it's one neighbor that's complaining about an eyesore on a neighboring property?
The bill addresses nuisances located on any unincorporated area of the county. So I believe that would include any in that 3-mile margin. In terms of where these nuisances are with the testimony presented, I'd have to defer to Commissioner Howell as to where those nuisances were located in that unincorporated area and what they're attempting to abate through these new procedures.
All right, I think we'll take that up next week, so maybe everybody can work on that, and Senator Bowers will wait till next week on yours as well. So we will take this bill up first thing on Tuesday. Is there anything else to come before the committee? Seeing none, we're adjourned. Thank you.